and the Sixth Committee. Lastly, I'd like to refer to the question of cooperation between ILC and ALCO. In order for the ILC to contribute to the promotion of the progressive development of international law and its codification, views from international community, particularly voices from Asia and Africa, should be properly reflected in its work. In that sense, the role of ALCO is of great importance. There could be several approaches for delivering our message, such as comments from governments toward special rapporteurs in response to requests from the Commission, or statements made in the Sixth Committee. Since the ILC places high regards on the debate in the Sixth Committee, active participation in the work of the committee by the ALCO members is particularly commended. Last year, during the debate of that committee, the government of Japan proposed establishing a mechanism reflecting more the needs from member states in the process of topic selection of the ILC. This year, the ILC decided to update the list of future topics, which is welcomed, as it will enhance further the transparency in the topic selection process. Thank you.
Thank you very much, Japan. May I now invite distinguished delegate from India to make your comments?
Thank you, Madam Vice President. We thank the Secretary General for his excellent summary on the topics under consideration. We are also very pleased to see the presence of Chairman of ILC as well as the two members of ILC amongst our midst. And I'm sure that their presence would give impetus to the members of ALCO states to respond to ILC questionnaires. We would like to thank the Chairman of International Law Commission for his overview of the work of the Commission this session, and Dr. Hasuna and Dr. Murase for their reports on protection of persons in the event of disasters and protection of atmosphere. On the topic of protection of persons in the event of disasters, India is in full agreement with the Commission that states should observe fundamental humanitarian principles in responding to disasters. The principle of solidarity and cooperation, along with the principle of humanity, neutrality, impartiality, and non-discrimination, as envisaged in draft Article 7, should be central to any disaster response. We would like to emphasize that disaster relief and assistance must start on the premise of respect for principle of sovereignty, territorial integrity, and political independence of the affected state. Therefore, we are assured that the rapporteur is ensuring balance between relief and sovereignty. There is need to ensure that the humanitarian assistance should not be forcibly imposed on the affected state, and the concept of international humanitarian law are not automatically applied in disaster situations, as the duty of protection in the event of armed conflicts differs from that of disaster situations. Madam Vice President, it is significant to note that the Commission had relied upon a variety of sources of law in order to identify the duty to reduce the risk of disasters, including international agreements and instruments, regional and national laws on prevention, preparation and mitigation, which also includes India's Disaster Management Act 2005. With regard to draft Articles 13 and 14, it is our understanding that the affected state should be entitled to impose conditions on the provision of assistance, and that the termination of relief operations should be ultimately a matter of decision by the affected state. Draft Article 14.2 prohibits arbitrary withholding of consent to external assistance by the affected state. We are examining the guidelines on what would not be arbitrary to see whether they would meet our concerns. Draft Article 18 establishes the obligation for the affected state to take the measures which would be appropriate in the circumstances to ensure the protection of relief personnel, equipment, and goods involved in the provision of external assistance. Here, it may be noted that the measures to be adopted by the affected state may vary in content and can imply different forms of state conduct due to the context-driven nature of the obligation. In particular, the flexibility inherent in the concept of appropriate measures suggests that the affected state may assume different obligations depending on the actors involved in potential threats to relief personnel, equipment, and goods. On the topic of protection of atmosphere, considering the threats posed to the atmosphere, in particular by air pollution, ozone depletion, and climate change, we agree with the rapporteur that the protection of the atmosphere is extremely important for humankind. In this context, there lies a general obligation for all states to protect the atmosphere. It is with interest we note that Professor Moraze dealt with the topic by providing a historical sketch of atmosphere in international law through diverse sources and subsequently through the relevant judicial decisions rendered by the ICJ in nuclear test case, Nagia Maro's case, pulp mills case, etc. The proposed 3 guidelines in the special rapporteur need an in-depth analysis since it involves technical, scientific, and legal issues. With regard to the concept of atmosphere as a common concern of mankind dealt with in draft guideline 3, legal status of atmosphere, the special rapporteur may explore more legal reasoning and justification to propose such a concept for this topic, as this concept is highly debated and less accepted in other areas of international law, particularly in outer space, as you're aware. While formulating the future guidelines, the special rapporteur may ensure that the interests of developing countries are protected in case of any obligations, and the principle of common but differentiated responsibility need to be considered and respected. The special rapporteur may also focus more on cooperative mechanisms to address issues of common concern, and this aspect may be given priority. Thank you very much.
Thank you very much, distinguished delegate from India, for those comments. May I now invite the distinguished delegate from the Islamic Republic of Iran to make your comments.
In the name of God, the most compassionate, the most merciful. Madam Vice President, the delegation of the Islamic Republic of Iran would like to welcome the presence of the chairman of the International Law Commission among us. It's the first time that a chairman of the ILC assists us in our deliberations on the topics included in the work of the International Law Commission. And this is specifically significant in that this happens to coincide with Iran's hosting the annual sessions of ALCO for the 53rd session and the 3rd time in its own kind. Madam President, my delegation would also like to express its appreciation for the enlightening presentations on the issues under consideration by the ILC. I should also thank the ALCO for organizing the special half-day meeting on selected items on the agenda of the ILC. We would like to make a few comments in this regard, namely on protection of persons in the event of disasters and protection of the atmosphere. The successful conclusion of the first reading of the draft articles on protection of persons in the event of disasters is commendable. However, some of the articles deserve special attention. Article 8 of the draft articles concerns the duty of the state affected by the disaster to cooperate. We have some difficulty to understand why the affected state must cooperate with the ICRC and the relevant non-governmental organizations. The commentary explains that a reference to ICRC is included as a consequence of the fact that the draft article may also apply in complex emergencies involving armed conflict. In our view, there is a contradiction between this commentary and Article 21 of the draft articles concerning the relationship it bears to international humanitarian law. This provision stipulates that the present draft articles do not apply to situations to which the rules of international humanitarian law are applicable. Even if we accept the explanation provided by the special rapporteur, Mr. Valencia Ospina, The obligation to cooperate in situations of armed conflict cannot, in our view, extend to non-governmental organizations other than the ICRC. By the same token, Article 13 of the draft on the duty of the affected state to seek external assistance raises some difficulties as well. This provision obliges the affected state to seek assistance among the states, UN, and relevant non-governmental organizations. This has been opposed by some members of the Commission who are of the view that international law as it currently stands does not recognize such a duty. We support the view expressed by the Special Rapporteur to include in the draft provision regarding the relationship to the Charter of the UN. Such a provision drafted in the light of Article 103 of the Charter will be useful to the extent that it will highlight the cardinal role played by some principles enshrined in the Charter, namely the principles of sovereignty and territorial integrity of the affected state already acknowledged in the draft. Such a reference can be found in the ASEAN Agreement on Disaster Management and Emergency Response. This inclusion would reaffirm, furthermore, the leading role to be played by the UN in disaster management. Madam Vice President, the issue of protection of the atmosphere is tightly linked with political, technical, and scientific considerations. This, however, does not mean that the importance of the legal issues surrounding the topic should be downgraded. In fact, the decision of the General Assembly to include the topic in the long-term program of the work of the Commission is based on such an understanding. The task assigned to Mr. Murase, the Special Rapporteur to that end, is fraught with difficulties. Therefore, the approach adopted should be applied with caution and ample flexibility to meet the expected purposes. This is justified by the mere fact that the Commission's task, as stated in the report, consists in, I quote, identifying custom, whether established or emerging, and identifying, rather than filling, any gaps in the existing treaty regimes. End of the quote. It seems that the Commission is well aware of the unique nature of the job. The question arises then as to the end result of the task undertaken by the Special Rapporteur. While the task is not aimed at filling treaty gaps in international legal instruments applicable to state activities in the atmosphere, it seems that the concerns about the topic deserve more than merely pure research. On the question of whether to include basic principles in the work of the ILC on the topic, which is stipulated in subparagraph B of draft guideline 2, we are of the view that having resort to basic principles of international environmental law is inevitable. Examining rights and obligations of states regarding the protection of atmosphere is impossible without expounding upon principles such as secu terra, polluter pays, cooperation, or precautionary approach. In his first report, the Special Rapporteur on the topic raised the question of the legal status of the atmosphere, which he considered rightly to be the prerequisite to the Commission's consideration of the subject. He favored the concept common concern of humankind. It seems that the normative content of the concept is still unclear and controversial. We agree that the protection of the atmosphere is a common concern of mankind. However, the question that can be raised at this juncture is what would be the legal implications of this new concept. We have already some clear idea about the consequence of the qualification of the seabed and its subsoil beyond the continental shelf as a common heritage of mankind. I am referring to the advisory opinion of the International Tribunal for the Law of the Sea, issued in 2011, regarding the obligation of states sponsoring persons and entities with respect to activities in the area. The tribunal refers to Article 48 of ILC Articles on State Responsibility by affirming that the responsibility of states to protect the environment of the area creates erga omnes obligations. We can draw a similar conclusion regarding the protection of the atmosphere. Drawing analogies from the law of the sea, it was suggested that consideration should be given to dividing the atmosphere in zones based on the degrees of sovereignty and control exercised by the subjacent state. In the end, we acknowledge the difficulty of the task of the Special Rapporteur due to the scarcity of state practice, which has led him to rely in the preparation of this report mostly on the views of non-governmental organizations and scholars. Thank you, Madam Vice President.
Thank you very much, Iran, for your contribution. May I invite the distinguished delegate from Malaysia to make your observations.
Thank you, Madam Vice President, Excellency Secretary General, esteemed members of the ILC, distinguished delegates. My delegation firstly joins the other delegates in thanking the Secretary General for his comprehensive report on the work of the ILC. We are further grateful to Mr. Gevorgian, the Chairman of the ILC, for his succinct elucidation of the works of the ILC at its just concluded 66th session. In the interest of time, I would confine my interventions on the two topics presented by the esteemed ILC members, as Malaysia's detailed comments on the ILC topics during the 66th session had been submitted to the Secretariat. I thank Dr. Hussein Hasuma for his presentation on the topic of protection of persons in the event of disaster. We noted that comments and observations of governments are expected by January 2016, as highlighted by Dr. Hussein. At this juncture, I will confine my preliminary comments on draft articles 14 bis, 17, 18, and 19, being the latest cluster that came out of the works of the Commission's drafting committee. Madam Vice President, in relation to draft article 14 bis, Malaysia notes that the drafting committee has renumbered it to draft article 18, of which the qualifier all was deleted and the phrase necessary measures has been replaced to appropriate measures to allow for a margin of discretion for the affected state in deciding which action to take. On this issue, Malaysia proposed for the words subject to the available resources and capabilities to be inserted after the words the affected state shall, as the standard of care or due diligence may vary depending on circumstances, which include economic situations of the affected state, the availability of technical expertise and resources, as well as the magnitude of the disaster. Malaysia notes that draft articles 17 and 18 proposed by the Special Rapporteur were renumbered as draft article 20, since the drafting committee is taking a simpler approach by incorporating ideas expressed in the two draft articles into a single article. Malaysia is favorable with the renumbered draft article 20, as in our view, it upholds the general principles of international law in governing the sovereignty, territorial integrity, and political independence of affected states, and shall remain sacrosanct. Mr. Chairman, Malaysia takes note that at the moment, the drafting committee has decided not to pursue with the draft Article 19, which deals with the relationship to the Charter of the United Nations. Madam Vice President, moving on to the next topic, I join the other delegates to thank Dr. Shinya Murase on his succinct presentation on the topic protection of atmosphere. In particular, we noted his outline of works expected to be concluded in 2018. Malaysia notes that during the 66th session, the Special Rapporteur, Dr. Shinya Murase, had submitted his report entitled The First Report on the Protection of the Atmosphere. Malaysia further notes that the expected outcome of the work of Dr. Murase will be a set of draft guidelines which will not seek to impose legal rules and legal principles on current treaty regimes. Malaysia observes that the first report by Dr. Murase laid down three draft guidelines. Firstly, on the definition of the atmosphere. Secondly, on the scope of the guidelines. And thirdly, on legal status of the atmosphere. In relation to the definition of atmosphere, I wish to inform that Malaysia is conducting an internal consultation, particularly with our domestic scientific experts, to ensure the acceptability of the proposed definition. On the scope of the guidelines, Malaysia notes the Special Rapporteur's proposal for the draft guidelines to address human activities that directly and indirectly introduce deleterious substances and energy into the atmosphere. In this regard, Malaysia is hopeful that Dr. Murase would elucidate the specific type of human activities intended to be covered under the draft guidelines. In our view, this is important to ensure that the activities proposed will not overlap with human activities already covered under existing international regime on environmental protection. Further, Malaysia is not familiar with the term deleterious substance as proposed in the first report. Hence, Malaysia is hopeful that the Special Rapporteur would provide clarification on the intent and the usage of the terms, as well as the other terms found, including energy, particularly on the differences of these terms with the common terms such as hazardous substances, pollutants, and wastes. Madam Vice President, on the legal status of the atmosphere, Malaysia is analyzing the 5 concepts highlighted in the first report, namely the airspace, shared or common natural resources, common property, common heritage, and common concern. We are of the view that detailed understanding of these 5 concepts could lead to the determination of the legal status of the atmosphere, which at this current moment, which we are not in the position to commit and comment. Thank you, Madam Vice President.
Thank you very much, Malaysia. The following member states have also indicated that they wish to comment on the topics: Syria, Republic of Korea, and Pakistan. So may I please invite Syria to make your comments.